The U.S. Supreme Court will hear a challenge to assault weapons bans.
Preparations are already underway to argue in favor of the Illinois ban.
Allow people to have weapons to defend themselves. They don't need a weapon that can fire that many bullets in a single second.
A military-grade weapon on the streets of Chicago is simply unacceptable.
The only category of firearms that were banned were those that were clearly dangerous.
There have been more and more shootings. It is getting worse and worse. Mass shootings have occurred in the workplace, on college campuses.
We need to keep illegal guns and military-type weapons out of our communities.
The Supreme Court has agreed to decide whether millions of Americans can legally keep the rifle sitting in their gun safe right now. The justices have granted certiorari in two consolidated cases, Viramontes versus Cook County and Grant versus Higgins, and for the first time in the court's history, they will rule directly on whether the Second Amendment protects the AR-15. That single sentence is worth pausing on. Not a lower court, not a circuit panel. The Supreme Court of the United States agreeing to answer a question that gun owners, lawmakers, and courts have argued about for over a decade without a final answer. The two cases came from opposite corners of the country. Viramontes challenges a long-standing Cook County, Illinois ordinance, a law that names 125 specific rifles as banned, including the AR-15 and the AK-47, and criminalizes any semi-automatic rifle with a detachable magazine that also has a pistol grip, a folding stock, a flash suppressor, or a barrel shroud. Get caught with one, and it is not a fine you can shrug off. It is up to 6 months in jail and a minimum $5,000 penalty. Grant versus Higgins comes out of Connecticut, a law passed in the raw aftermath of the Sandy Hook shooting. Connecticut's ban goes further than most, prohibiting rifles both by brand name and by a list of physical features, making it one of the broadest assault weapon statutes in the country. Both laws were challenged. Both laws were upheld by federal appeals courts, the Seventh Circuit for Cook County and the Second Circuit for Connecticut. And normally that would be the end of it. A circuit court rules, the losing side appeals, and the Supreme Court, faced with two courts that agree with each other, simply declines to get involved. That is not what happened here. Think about what that actually means for the roughly 20 to 30 million AR-15 owners across the country. For over a decade, the legal status of the rifle in their closet has depended entirely on which state line they happen to live behind. Own the exact same firearm in Texas or Arizona, and it is treated as an ordinary hunting and sport rifle. Own it in Cook County or Connecticut, and it is a criminal offense carrying jail time. That patchwork has existed for years, and it has never been resolved at the national level because the Supreme Court kept declining to touch it. The justices took the case anyway, with no circuit split, no disagreement between appeals courts forcing their hand. And in the world of Supreme Court watching, that detail changes everything about how this case reads. Legal analysts point out that the court does not typically grant review just to rubber stamp a lower court's decision. When the justices reach down and grab a case nobody forced them to take, it is usually because they intend to change the law, not preserve it. The two cases have been consolidated into one, with a single hour of oral argument allotted, expected sometime in the fall as the October 2026 term opens. A ruling is expected by June of 2027. So what exactly are the justices being asked to decide? The formal question presented is narrow on paper but massive in consequence. Whether the Second and 14th Amendments guarantee the right to possess AR-15 platform and similar semi-automatic rifles. Strip away the legal language, and it comes down to this. Is the most commonly sold rifle in America a protected constitutional arm, or is it a weapon governments can ban outright? This did not come out of nowhere. A year earlier, the court had the chance to take a nearly identical case out of Maryland, Snope versus Brown, and passed on it. But that denial was not silent. Justice Brett Kavanaugh, while voting against hearing the Maryland case, wrote separately that the court, in his words, should and presumably will address the AR-15 issue soon. He went further, stating there is a strong argument that AR-15s are in common use by law, abiding citizens, and are therefore protected, noting that Americans currently own an estimated 20 to 30 million of them. That was a signal. Not a ruling, not a promise, but a sitting justice publicly marking the calendar. And now, one term later, the case he seemed to be waiting for has arrived. Reactions split immediately along predictable lines, but the language on both sides gives away how high the stakes actually are. Gun rights groups involved in the case argue that rifles owned by tens of millions of Americans cannot reasonably be placed outside constitutional protection simply because of how they look. Gun control advocates counter that these are the exact weapons used in the country's worst mass shootings, and that removing the ban would strip away what they call a critical public safety measure. Neither side is treating this as a minor procedural update. Both are treating it as the fight. It helps to understand how we got here. The Supreme Court previously handed down Bruin, a ruling that rewired how judges are supposed to evaluate gun laws. Instead of weighing a law's public safety benefits against the burden on gun owners, courts were told to ask a different question. Does this restriction match the text, history, and tradition of firearm regulation going back to the founding era? Later in Rahimi, the court clarified that a modern law does not need a perfect historical twin, just a comparable historical justification. That shift is exactly why this case matters so much. Under the old balancing test, a state could argue that a rifle's rate of fire or magazine capacity created enough public danger to justify a ban. Under Bruin and Rahimi, that argument does not work anymore. Instead, the government has to show that 18th or 19th century America had something comparable to a modern assault weapons ban. And there is no historical tradition of banning firearms based on cosmetic features like a pistol grip or a barrel shroud, because those features simply did not exist as legal categories 200 years ago. That is the argument the challengers are expected to lean on hardest. The government side is expected to counter with what is sometimes called the militarily useful weapons argument, that AR platform rifles derive from military design and fall outside the category of arms historically reserved for ordinary civilian self-defense. Which argument wins is genuinely unresolved. This is not a case where legal experts are confidently predicting a landslide in either direction. It is being described as the biggest Second Amendment case since Bruin itself, precisely because nobody can say with certainty how it ends. There is also a wrinkle sitting underneath this case that few people are talking about yet. Earlier in this same term, the court handed down a separate ruling, Trump versus Casa, that sharply limited the power of individual federal judges to issue nationwide injunctions blocking a law everywhere at once. That ruling means relief in a case like this may end up applying only to the specific parties in front of the court, rather than automatically wiping out every assault weapons ban in the country in one stroke. In practice, that could mean a win for the challengers, still leaves other states' bans standing until they are separately challenged state by state. In the years that follow, what is clear is the scale of what is riding on it. A ruling striking down these bans would not stay contained to Illinois and Connecticut. Similar assault weapons bans currently sit on the books in roughly a dozen states, including California, Maryland, Massachusetts, New Jersey, New York, and Washington. A sweeping ruling could invalidate all of them in one motion. A narrower ruling could leave some restrictions standing while striking others. Nobody currently knows which version the court will choose. There is another layer worth noting. In the same batch of end-of-term orders, the court quietly held over 3 related cases without acting on them at all. Duncan versus Bonta, challenging California's 10-round magazine limit, Gators Custom Guns versus Washington, and a case out of Connecticut that raises both the rifle and the magazine question together. None of those were granted. None were denied. They were simply set aside, seemingly to wait and see what happens with the rifle question first. The court also denied review in a separate cluster of cases dealing with age restrictions on buying or possessing firearms as an adult under 21, leaving federal appeals courts split 3-3 on that separate question, unresolved for now. So the picture forming is not one giant ruling that settles every open gun rights question at once. It is a single, enormous question, the AR-15, moving to the front of the line, while several other major fights, magazines, age restrictions, wait behind it. That sequencing may not be an accident. By resolving the rifle question first, the court effectively builds the foundation that every later magazine and age restriction case will have to stand on. If AR platform rifles are ruled protected arms in common use, that same reasoning becomes the baseline the justices reach for the next time a magazine capacity law or an age-based restriction reaches their docket. One case, in other words, may end up shaping the outcome of several more before this decade is out. Briefing has not even begun yet. Both sides will file written arguments over the coming months. Expect amicus briefs from gun rights organizations, gun violence prevention groups, state attorneys general on both sides, and very likely from the federal government itself. Oral argument will not happen until the fall, and whatever the justices decide will not become public until some point before the term closes in June of 2027. Until then, existing bans in every state that has one remain fully in effect. Nothing changes today. Nothing changes this year. What has changed is that for the first time there is a fixed date on the calendar when the country will finally get a constitutional answer to a question it has been arguing about since long before most current gun laws were even written. That's it for today, folks. See you in the next video.